My name is Jim Sellers. I'm a plaintiff's trial attorney who practices in Oregon, Washington, and I'm going to try and answer some questions for you that I have clients ask me those services, and those become a part of the claim. And then, of course, any loss of wages that the injured party has sustained. In my office, as in most offices, there's paperwork which is given to the patient to fill out and have somebody with their employer sign to verify it, which demonstrates the loss of wages. And of course, the doctors, to demonstrate the loss of wages, have to take the injured person off of work in order to collect for those items. So those are the things that we need to put together and accumulate. Unfortunately, in a lot of cases, we can't get those records until the treatment's completely over. As for instance, if the treatment is chiropractic care or physical therapy, the patient is going in routinely maybe a couple of times a week or more often than that. And so as each week goes by, there's more records and there's more bills. And with those kind of providers, we usually wait till the treatment's completely over before we request them. Otherwise, we're at risk that we'll get some segment of the records and bills and have to pay a fee for it, and after we get those records and bills, we need to request more, they'll send the ones they've already sent and charge us for them. So it's kind of a messy affair, accumulating the records and the bills, but that's what's involved. So when we have all this information, we sit down and review everything, and then we prepare a written evaluation of the patient's claim against the person who caused their injury. And we call that a settlement demand. What it really is a legal evaluation of why the patient is entitled to recover money from the party who injured them. And it demands that the insurance company pay money in settlement of the claim. Now, in my office anyway, we sit down with the patient, our client, and talk to them about what the value of the claim may be. And we agree on a figure that we're going to ask the insurance company to pay. Two things that a person needs to know about that figure. One is the insurance company will never pay it. They'll expect to negotiate. And two, everything that has to be paid comes out of that figure. So for instance, there's an attorney fee that gets paid out of the figure and costs. And if the patient's own insurance company or a carrier has paid for treatment already or for wage loss, they're entitled to be repaid frequently with, they're required to make a contribution to the patient's attorney's fees and costs. That's the law of the state of Washington. In Oregon, the other state I practice in, that works a little bit differently, but it's a little too complicated to go into in this one video. But so whenever you talk to your attorney and you're talking about money, you're talking about a gross sum of money, and you need to ask the attorney what gets paid out of that, because what you as the client are going to be interested in is what you will recover in your pocket. So we send that settlement demand out, or that legal evaluation, which is what it is, asking that the insurance company pay a sum of money in settlement of the claim, and that opens a period of negotiations, which is usually 1 to 2 months, can be longer, can be a lot shorter. And the insurance company can be expected to counteroffer with a much lower sum in response. Sometimes it's shockingly lower, and then we go into a period of negotiations to figure out whether we're willing to settle for the maximum amount of money that ultimately we can get the insurance company to agree to settle to. Now, my practice is I never submit a sum of money in settlement of the claim unless my patient or my client